Christmas.
Please rise. Court's back in session.
Can it show up the other thing? Yeah, okay. Back on the record, People versus Leticia Astacio. Please come back up, Mrs. Astacio. This is a violation of probation matter. The matter scheduled today for possible disposition due to the fact that we don't have a probation officer here.
Before this even starts, understand what's on the line here. This isn't a trial, it's a probation violation hearing. That matters because the legal protections are already thinner, and the consequences. They can be immediate and severe. Watch how fast this courtroom goes from procedural to personal.
In front of us. And I know I've said this to you several times since we've met. You have the right to an attorney through all stages of these proceedings. You continue to represent yourself at the previous hearings and the dates we've had here. Is that your wish today?
Yes, Your Honor.
Okay, you understand that you have the right to an attorney. You're waiving that right.
No, Judge, I'm proceeding as my own
I
attorney.
understand that. Okay. And so can this matter be disposed of today? That was the last question that we had here on the record. You have a copy of the Declaration of Delinquency alleging 3 violations of your probation. Is it your position that you wish to admit today and go forward with sentencing?
Yes, Your Honor.
Okay. Mr. Kwam, is that your understanding as well?
Yes, if she is willing to admit, then yes, that's up to her, but that's fine.
All right, Mrs. Astacio, you have several rights that you'd be waiving in exchange for admitting to the violations this morning. First of all, is your...
This moment right here is critical. By admitting the violation, she's waiving major constitutional protections. No attorney, no hearing, no witnesses, no cross-examination. In plain English, the court no longer has to prove anything. Sentencing becomes the only real question left.
You're waiving your right to have an attorney with you. You are an attorney, I understand that. You also have the right to a hearing where the people have to prove that you violated the terms and conditions of your probation by a preponderance of the evidence. Do you waive your right to a hearing?
I do.
Do you also waive your right to cross-examine the witnesses that the prosecutor would call to testify against you at the hearing?
I do.
Do you also waive your right to call your own witnesses in your defense at the hearing?
Yes.
And you waive your right to testify at the hearing, although no one could force you to testify.
Yes.
Are you making this admission knowingly, voluntarily, and intelligently?
Yes.
Has anyone forced you or threatened you or promised you anything in exchange for your admission?
No.
Do you feel under any duress or coercion at the present time?
No.
Are you under the influence of any drugs or alcohol right now which would cause your judgment?
No.
Do you recall being placed on probation by Judge Aronson?
Yes.
Did you receive a copy of the terms and conditions of the probation sentence?
At some point.
Okay, at some point.
Yes.
Okay, but you did. Is that correct?
Yes.
I'm sorry?
Yes.
Okay. In fact, you did sign off on the conditions of probation.
Yes.
Okay. Did you understand the terms and conditions of probation?
Yes.
Do you admit that you failed to report as directed to probation on August 13th, 2019 and August 20th, 2019?
Yes.
And you admit that you didn't appear to probation for a few months thereafter?
Judge, with all due respect, I think that the one admission is sufficient for the declaration of delinquency.
If you don't want to answer that, you don't have to.
I don't want to.
Do you admit that you failed to cooperate with the ignition interlock program as required by Section 1193 Subdivision C?
No. No, I don't admit that. I deny that.
You deny that?
I do, but I've already pled guilty, Judge.
Did you admit that you failed to abstain from using or possessing alcoholic beverages?
No, I don't.
Okay.
Notice what just happened. She admits to one violation but draws a hard line on the others. And legally, that's enough. In probation law, a single admitted violation opens the door to full sentencing authority. Everything after this is about discretion, not guilt.
Mr. Kwan, are you satisfied with just her admitting to paragraph 1? Or
Your Honor, I believe in order for the court to find a violation of the probation has occurred, she only needs to admit to the one violation. And if the court is satisfied, the court is in a position to sentence her accordingly. But in terms of whether or not she has adequately pled, the people are in a position of yes, she has.
All right. The people are satisfied, I'll be satisfied as well with your admission that you didn't show up to probation beginning August 13th and August 20th, 2019. And therefore, I will find that you violated the terms and conditions.
And just like that, the courtroom shifts gears. The judge has made the finding, the violation is official, and now we enter the most unpredictable phase of all. Sentencing. This is where law meets personality, and where things can turn fast.
Conditions of your probation, that you did so knowingly. Now, with regards to sentencing, do you wish to be heard?
Briefly, Your Honor, obviously, as a violation of probation, it is up to the court to sentence Ms. Astacio as she sees fit. However, it is the position of the people that, based on not only her violation of failing to report, but her violation of the conditional discharge that put her on probation in the first place, her inability to adhere to probation going forward from that, that it is the people's position that the only alternative left to the court is to sentence Ms. Astacio to a term of incarceration, and that would be the position of the people.
Ms. Astacio?
Judge,
This is a curveball. The prosecution is now asking for incarceration, despite earlier signals suggesting time served. In courtroom dynamics, this kind of reversal can completely change how a judge views credibility, consistency, and intent.
honestly, I'm blindsided. I've spoken to Mr. Fromm about this several times, and his position has always been that the people take no position. In fact, in pretrial conferences, he's asserted that a time-served disposition would be appropriate in light of the fact that I've served approximately 4 months in jail on a misdemeanor DWI. So I'm surprised that he would make this statement on the record, on the news, for the first time ever. I think it's disingenuous at best. But Judge, I think that it's easy to lose sight of the facts in this case. This case, like a case that I've cited before, People v. Purpura, which is a county court case, which was appealed from the Monroe County District Attorney's Office, when an individual who got probation was sentenced to 9 months in jail. Judge Chasho, county court here, said that that was inappropriate, and he conducts an entire analysis of why it's inappropriate. What he says is that no matter what happens in a criminal case, you always go back to the initial crime, the initial offense. In that case, as in this case, it was a misdemeanor DWI. You look at the defendant as you find them at the time of the arrest. In my case, I was a city court judge. I had never been arrested in my life. I had never been charged with any offenses. You sentence the person based on what actually occurred. In my case, I passed my field sobriety test, but after conviction, I again had no evidence of an accident, there were no injuries, there was no aggravating factors. It was a standard misdemeanor DWI, for which most individuals would receive fines and a surcharge. Irrespective of what happens from the point of sentencing, and this isn't my words, Judge, this is Judge Chasho, who's a county court judge here, you always go back to that initial offense. This is still a misdemeanor DWI. This is a misdemeanor DWI that was alleged to have occurred in 2016, and we're going into 2020. I have served almost an entire year of a conditional discharge. I have served approximately 4 months in jail. I have served 2 years on probation. I'm not saying any of this to say, woe is me. You weren't the initial sentencing judge. I want you to be aware, if we're talking about penalties, of the penalties I've already sustained in this case. In addition, I was removed from the bench. Literally, the Court of Appeals held that career suicide was appropriate in my case, so I lost my entire career. I think if we're going to talk about penalties and justice and equity, this is an atypical sanction for a misdemeanor DWI conviction. In addition, one of the reasons that a person would be placed on probation, and this is again in the People v. Purpura decision, is substance abuse, which apparently has been the overarching concern here, that I have a problem with alcoholism. I've never been able to provide any proof to the court that I've completed an alcohol treatment program because I've never been ordered to attend one. I've obtained 3 to 5 OASIS certified evaluations, and none of them ever said I needed treatment. It is impossible for me to enter into a treatment program without a diagnosis. That's just not how insurance works. So I did voluntarily enter into one program that I completed, but that's all I could do. If I'm on probation to address a substance abuse issue, that certainly isn't occurring before this court because there's no proof that I have one. I got a mental health evaluation. There was no recommended treatment, but on my own, because candidly this was very stressful, I got into therapy. I provided information from my therapist to my probation officer voluntarily. My therapist said, you need this to be over. What you're seeing is suffering from situational depression. You cannot move on with your life because this will not end. I provided proof of that to the court. I provided proof of that to probation. I am not here out of defiance. I am here because the judicial system does not function to break people, and it is destroying me. Irrespective of what I look like when I come into court, whether I'm smiling and happy, this is difficult every day. It is embarrassing, it is humiliating, and I cannot move forward. I cannot represent my clients because my mind is cloudy. I cannot come into court because I'm denied access regularly. I could not get here on time today because I have to stand in line. I cannot get a secure pass. It is difficult for me to get into the jail to see clients that I need to visit. It is difficult for me to work, and probation is supposed to help me, not harm me. If your point was to penalize me, I'm telling you, you have. If your point was to destroy me, I'm telling you, you can't. Irrespective of whether you jail me for the rest of the term that is left here or not, I can't function this way. So I've done quite a bit of time here, more than I think any other individual ever convicted of a misdemeanor DWI has done. I think that I have lost quite a bit, but I've gained so much in the process. If the point was to teach me or to help me, I don't know that you did, but I can tell you through this process, I've grown so much as an individual. You don't know me, but you literally can see the difference in the person that I've been through this. And to continue to be stuck just because there is literally no benefit to keeping me on probation. In fact, I am the only probationer that my probation officer supervises. You want to talk about a waste of taxpayers' money? I'm his entire caseload. There's no benefit, Judge. You want me to serve the community? I do. I planned on going to a Thanksgiving dinner tonight. If you don't decide to incarcerate me, I'll be there. I'll be serving at Sabrino's this week. I do community service regularly because that's who I am as a person. If you'd like to sentence me to that, I could see a purpose there and I do it anyway. I think the appropriate disposition is time served, and people v. Purpura tends to support me. I think that that's a binding decision. I think the court's bound by it. But aside from that, Judge, aside from legalities, and I think that the right thing to do here is to end this. And honestly, candidly, I would like you to do that with a time served disposition. But no matter what you decide to do, I'm thankful that this will be over today. This has stopped my life. Judge, also, there was a motion that was filed. I know that the court ruled on it. Specifically, there was an ignition interlock device portion of that motion where I addressed the fact that I've been serving that sentence for in excess of 3 years, which I believe is illegal. Irrespective of the court's decision today, I would ask that you sign the order terminating the ignition interlock today as a part of your sentence. And I would just throw myself on the mercy of the court, Judge. Thank you.
That was more than an argument, it was a narrative. She framed this as punishment turning into destruction, not rehabilitation. She cited case law, personal loss, mental health, and proportionality. The question now isn't whether she violated probation. It's whether the system believes she's learned anything from it.
Thank you for letting me speak.
I don't feel the need to respond in depth to her feelings. I do believe she misrepresented what I said about the court's options in our pretrial conference. But that's neither here nor there. I think what matters is that people who are on probation do not get to decide when their terms of probation end. And I'll leave it at that.
Thank you. So this case started with you being charged with driving while intoxicated and convicted after a trial for driving while intoxicated, which I consider a very serious offense. The facts surrounding your arrest that morning, very troublesome to me. But your actions after your conviction are even more troubling to me. You received the minimum sentence of a conditional discharge upon your conviction for driving while intoxicated. You had a year period to stay out of trouble, pay your fine and surcharge, put a ignition interlock device on your car, and follow the restrictions of the device. And almost a month after your conviction, you already had a violation of a conditional discharge filed. Within 2 months, you had 2 more filed against you. You settled it. You admitted to a violation. The judge extended your conditional discharge provisions to include an additional time period on your ignition interlock device. That was it. 6 months later, you're back on another violation of conditional discharge. The judge places you on probation. Shock portion, yes, you did serve some time. Instead of revoking your probation, he gave you another chance. Placed you on probation. You're back again on a violation of your probation. You've been given several chances before today, before appearing in front of me. What I have found is, and what shocks me, is that you've absolutely never taken any responsibility for your actions. You've never shown any remorse throughout this entire process. Shocking to me. What's also appalling to me is that you unilaterally decided to take yourself off probation without a court order. You just decided you didn't want to go anymore, so you stopped going. I'm not happy about it. I'm not going to tolerate it. Your actions show that you do whatever you want to do whenever you want to do it.
This is the judge drawing a final line. From the court's perspective, probation is a privilege, not a negotiation. And once the judge concludes there's no accountability or remorse, discretion disappears. This sentence isn't just punishment, it's a statement.
And it stops today, and it stops now. I'm revoking your probation, and I'm resentencing you to 180 days in jail, starting now.
Thank you, Judge.
I will grant your relief with regards to the ignition interlock device. You no longer have to have it installed on your car. I will also sign an order to allow a family member to get it taken off of your car in a timely fashion.
Would that be today?
Astacio, you're going to have some time to think about what your actions were throughout this proceeding. It's quite possible you single-handedly changed the view of our community to the judicial justice system, or judicial system of justice. And it's appalling what you've done, and I hope you've learned your lesson. Case closed. Demetrius Bostic, is he here?
My cousin. I'll get you the camera.